Hello everyone, I'm Shauna Sanford. Welcome to the special webcast edition of John Redmann, Power of Attorney. Along with me, of course, Attorney John Redmann. And our guest for this interview segment, Attorney Tim Meche, who is a legal analyst and has so much information about a very important topic that we're going to be delving into called computer access device fraud. First of all, Tim, welcome. It's great to have you here.
Good to be here.
Tell us about this new law.
Well, there is a law in the books that Congress enacted a few years ago to prevent people from, quote, hacking into computers. Congress being Congress, however, when they enact a new law, they generally throw in all sorts of other things. And they wrote an extremely broad statute, which not only makes it illegal to access a computer without authorization, which is understandable,
right,
but it also deems it illegal if you, quote, access a computer with authorization, but while using the computer, you, quote, exceed your authorized access.
Explain that. Exceed the authorized access. Tell us that in lay speak.
Well, that's one of those vague terms that could mean whatever a prosecutor says it means. There is a reported case from the Ninth Circuit Court of Appeal in California in which the chief judge, who found the law to be unconstitutional, said it could mean employees at work who, instead of working, go to Facebook or go to a sports site.
So
or
they would be criminals under
his conclusion was that they would be in violation of the federal law. And they'd be at the whim of any federal prosecutor who decides when and when not to prosecute somebody.
This affects so many people because there are lots of employees who are on Facebook while they are at work. In some places, it's even required that you're on Facebook. And I guess perhaps at some point, instead of just conducting official workplace business, you might, take some liberties and do some personal things. So this could get very murky.
Yeah, and it affects a lot, and the court pointed this out, it affects a lot of employer-employee rights type litigations. Because let's say you have an employer that wants to get rid of an employee, but he doesn't have just cause. But then he says, well, wait a minute, you're on our work computer, you're doing things that are in violation of federal law. Now I have just cause. What
if I'm on a break, though? What if I'm on a break, I'm taking my lunch break, and I'm using this time to conduct some personal business?
Check your email.
It would depend upon whether or not, under the office's policy, that constitutes exceeding your authorized access. If there's a written policy, and after this law came out, a number of major corporations, IBM and others, issued written policies on what you can and can't do on your computer. They were tightly written, subject of a lot of disputes between unions and employers. This raises a lot of issues in the employee rights area of concern.
Has this is a federal statute, a federal law, has it been tested in our federal courts here?
Yes. There's currently a split amongst the federal circuits as to whether or not this is constitutional. The Ninth Circuit issued an en banc opinion, and that means the whole members of the court. It's a significant opinion.
Judge in the Court of Appeals. That's the
court
of California.
For the rest of us who don't know this, what again does that mean?
John, why don't you explain?
En banc means every single judge appointed to the Ninth Circuit Court of Appeals in California. They got together and they voted, and a majority of those judges decided that that law was unconstitutional.
Okay.
And it's significant because usually it's only a panel of 3 judges, but when the full court considers an issue like this, it gives more weight to the opinion.
That might be a dozen judges. That might be 15 judges. I'm not certain how many judges are on the Court of Appeals in California.
And so then how does that impact things going forward?
Well, currently under the jurisdiction we're in Louisiana, which is the Fifth Circuit, which governs Louisiana, Texas, and Mississippi, the courts have found this to be constitutional. And there's cases where they're allowing people to be prosecuted for getting on a computer with authorization, but exceeding the employer's authorized use.
Okay, so not to be confused, then in California they found it to be unconstitutional.
Correct.
But here in the Fifth Circuit, which governs our state,
and Texas,
and Mississippi, they have found it to be constitutional.
Correct. Yeah, and other circuits are weighing in on the issue. Ultimately, this will probably be settled by the U.S. Supreme Court.
And to be clear, it's really aimed at people who either you hack into somebody's computer when you have no business being on the computer, or you're given access to the computer, but you break into something you have no business being in, the financial records, and you're stealing information in order to steal money or to steal private data. Those are the clear-cut examples. But unfortunately, the way the law is written, you could be a criminal just because you got on Facebook, or you, on your break, you were simply trying to check your email. And that's the beef, and that's the concern, is people should not be turned into criminals for doing something that, heck, everybody should be allowed to do, is, if I'm understanding the point you're making.
How many businesses are even aware of this?
Oh, I think every major corporation has a legal department that's aware of this. This has been the subject of more civil employer-employee discrimination cases than criminal cases. It's rarely been used in criminal law up to now. So I think the major corporations are aware of it. I think some of the smaller corporations are not.
And let's flesh it out a little bit more. This applies in situations where an employer has a written or perhaps even verbal, a spoken, if not written, rule, or does the statute not say?
John, it's so nebulous and so vague, the statute doesn't say. Obviously, ideally, it should apply if there's a written policy, but it doesn't limit it to that. It could be a verbal policy.
So in the ideal sense, if the law is going to cause less headaches, if you're an employer, let's say, and you have a rule that says, you can work here, you can get on the computer, but we strictly forbid you from using the computer for any personal use. And it's a written policy, and it's clearly written, and you sign and date it. If you want to use a computer for personal reasons, you may not work here. In that situation, well, shame on you if you are caught trying to do something personal on the computer. In that situation, well, shame on you if you break the rules. But if you have no spoken policy, in fact, lots of people you see other people using the computer for personal use, and then you get caught using it for personal use, well, then you might call, you know, an attorney like Tim Meche if you get fired. But anyway, I just want to be sure that I'm fleshing out the
I mean, I think
details.
it's an example. You know, Congress is often criticized for over-intruding in our personal lives, for legislating about things that they have no business doing. Obviously, if you're hacking into a computer to steal money out of a bank account, Congress should make that a crime and it should be prosecuted. But should Congress be stepping into the area between employers and employees and what their employees do or don't do on the computer in their spare time? There's a question of whether or not Congress has any business going there, and I don't think they do.
And an employer doesn't need a law to say you're going to be fired if you are doing personal work while on company time.
But the employer should make that clear to the employees, right?
Sure,
it can't just
absolutely.
be, you know, you should know.
Exactly.
It has to be, whether it's written or it's verbal, it should be communicated to the employees.
Well, in an employer-employee context, yes, but the old adage applies, ignorance of the law is no excuse. So even though you're not aware of this law, you can still be prosecuted for it.
And same thing, while you're at work, you don't need to be told you're supposed to be working while you're at work. You should not assume it's okay to get on the computer and play video games or check your email when you're on the employer's time clock.
Sure.
Use your common sense too.
That's right. Use your common sense. Thank you so much, Tim. It's been a pleasure having you on. Learned a lot. Computer access device fraud.
And for your viewers, the title of that law is Title 18, United States Code 1030.
What we'll do is we'll put it on our website too, so you can check it out and download a copy. We'll hopefully we'll get our webmaster, Mr. Stokes, to take care of that for you too.
Thanks so much for joining us, and we will see you next time.